Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. I have noted the public was notified of a sealed, closed, remote hearing that is scheduled to occur today, and today is May 5th, in this extremely high-profile case involving mass unaliving, Idaho versus Kohberger. I've done a prior presentation on this topic. If you have not had an opportunity to listen to it and watch it, I ask that you do, because it will provide you some feedback as to why this hearing notice is so unusual and represents a first in this case, where so much has been withheld from public access, dating back to the early days of the case, when both sides, the defense and the state, went to the then presiding judicial officer, Magistrate Judge Megan E. Marshall, in Latah County, as they did on January 3rd, 2023, and asked for a non-dissemination order, aka a gag order. And they received that non-dissemination order on that day, January 3rd, 2023. Now, bear in mind that Mr. Kohberger was arrested the 30th of December, 2022, as to how early in the case that non-dissemination order was entered. And because of that non-dissemination order, we have not seen the type of things meant to keep the public informed as to the case, such as in other profile cases, you will routinely see law enforcement giving an interview once in a while, or one of the parties, the defense counsel or the state, doing the same. We've not had one such event because of this non-dissemination order. Then on top of it, I invite you to look at the case summary page, at all of the items from the beginning of the case that has a lock and key icon next to it. That tells you that that filing is under seal. There have been many hearings under seal, but there has never been a hearing notice that I can remember seeing in this case where there was no subject or topic for the hearing given in the notice of hearing. To give notice to the public as to what's the purpose of this hearing, why is it being convened, as happened today in this May 5th, 2025 hearing. Remote, closed, sealed. Absolutely no topic given. There has been so much speculation, wild rumors and theories that have ignited people's imagination all over the world. I believe that the reason why there has been so much speculation, doxing of people, naming of people as being suspect in the case, is because of the secrecy of the case. Now, I'm not condoning or offering excuses. I'm giving my opinion as to what the reasons are, why there has been so much rampant speculation over the case, up to and including what is the purpose for this hearing today. I gave my opinion why I don't think that this is a resetting of the jury questionnaire hearing, that was supposed to happen in mid-April. That was publicly noticed in the court's October 9th, 2024 order, which, by the way, we learned by looking at the case summary page was canceled, although there's no written notice of hearing stating that that jury questionnaire closed and sealed hearing was ever canceled. And I fail to understand, if that's the purpose of today's hearing, which many people are speculating over, why it wouldn't be noticed if it was noticed originally on October 9th, 2024. There's also some speculation that this may be a setting of a hearing on the state's motion for an examination of Mr. Kohberger. I'm going to give my opinion. Again, I'm speculating here, but I do not believe that this is for that purpose, and I'm going to explain why. As with this motion, which was filed on April 25th, 2025 by the state, there is what's called a schedule of briefings. A motion is an application for a court order. There are usually 3 filings in the briefings schedule on any motion, and you can look back to the beginning of the case. Motion to compel discovery, you're going to see motion, response, reply. The originating party files the motion to compel. The other side files a response, typically in opposition, and then there is a reply where the originating party replies to the response. One final opportunity to convince Judge Hippler, or if it was Judge John Judge when this matter was in Latah County, why the court should grant the motion and disregard the response. Motion, response, reply. Briefings are then closed, and then a hearing happens. We could look at what happened here. Motion filed April 25th, 2025 by the originating party, State of Idaho. Response filed 4 days later in opposition by the defense. Then comes the notice of the sealed closed hearing on the topic unknown on April 30th, 2025. And then 1 day later comes the reply from the originating party, i.e., the state of Idaho. Now, these documents, for the most part, are under seal, including the 2 declarations that were filed in support of the motion by the state of Idaho. Now, let's look at other filings in the case. Go to the October 9th, 2024 redacted order governing further criminal proceedings and notice of trial setting. This is the order that Judge Hippler signed shortly after defendant's motion for change of venue from Latah County occurred. The court entered this order, and you can see that this is, for all intents and purposes, the pretrial and trial order directing the date of voir dire, which is the process of jury selection, the jury trial itself, inclusive of penalty phase, if any, and other important matters. Now, if you go to page 2 of this order, you are going to see the briefing schedule for various motions. And you will see that it is always motion, response, reply, and then the hearing is scheduled. Case in point, any of them follow this order. Let's look at the Rule 12 ICR motions. 3rd bullet, page number 2. All motions governed by ICR 12, that's a rule of court, ladies and gentlemen, including motions to suppress evidence, are due November 14th, 2024. Responses to those motions are due December 6th, 2024. Replies are due December 20th, 2024. A hearing on the motions will be held on January 23rd, 2025 at 9 a.m. and continue the following morning at 9 a.m. if necessary. And if you check the docket, and you can do so by plugging into any search engine of your choice, Idaho cases of interest, you'll be sent to a website maintained by the Idaho Judicial Branch. You will see there one of the cases, Idaho versus Kohberger. Click on that link. It will pull up a number of options for you, including where you can watch live hearings as the public. This is public access to those hearings that are live. You click on that, it'll bring you to another page. If you look at this docket here, you will find that those motions were filed at or before the time the deadline set by this court order. So were the responses, so were the replies. Court then had a period of time to review all of the documents before oral argument on the filings occurred. So, with that said, although it's possible, I don't believe, in my opinion, that I give under our First Amendment to the United States Constitution, freedom of speech and of the press, that this is a hearing on that motion for an examination of Mr. Kohberger, which apparently the defense is opposing, because it was set before the reply. And the hearing came within days of the motion being filed. One final point about the case is this secrecy and the precedent that it is setting with respect to the First Amendment of the United States Constitution. We've seen on multiple occasions both sides citing to various amendments to the United States Constitution, all of which are extremely important. The Fifth Amendment is sometimes cited. The Sixth Amendment is sometimes cited. The 14th Amendment, Due Process Clause, sometimes cited. But before all of those amendments come the First Amendment. And I think that that's not by accident. I think that that was what was important to the framers of the Constitution and the states that ratified that Constitution. I fear the precedent that this case is setting, that a case this important, involving a mass unaliving where one person and one person only has been arrested, I think that the public is entitled to access to learn if they do have the sole and the correct defendant or not. We're being treated, in my opinion, as children in this case by not being given the reason for a hearing 2.5 years after this case was initiated, as is happening today in this closed and sealed hearing. That is my opinion that I continue to give, pursuant to the First Amendment of the United States Constitution. If you have any comments or questions or feedback or input, please leave it here. And I want to thank you, as always, for joining us here today.